flood, legally the concept, of course, is expanded to cover any act which post a contract is an act attributable to a superior force, maybe an act of God or maybe something beyond that, which is uncontrollable by the parties to the contract. It is unexpected and uncontrollable in their context. And the act is such that it actually impacts a contract in terms of the ability of the parties to continue to perform the contract. So it is these ingredients of an act of a superior authority, an act which is uncontrollable and unexpected, the impact of which is on contractual performance. Now, if we go to the next slide, which is titled Legal Provisions Relating to Force Majeure, if we see this doctrine as in the context of the Indian Contract Act, we do not have any mention specifically of force majeure as a concept. What we do have is, of course, specific provisions of the Indian Contract Act, Section 56 and Section 32. 56, which deals with frustration, and 32, which typically deals with contingent contracts, but again deals with the impossibility in relation to contingent contracts. And if we see 56, which in a way embodies the doctrine of frustration, you are faced with two essential concepts, where either prior to making a contract or after making a contract, if either the performance of the contract becomes impossible or it becomes unlawful, then in either of those situations, the consequence of that on the contract is that the contract can be voided. And therefore, the two key concepts are A, impossibility, two, illegality. And if a contract or its performance is afflicted either by impossibility or is afflicted by the aspect of illegality, then in these two situations, the contract would effectively be voided. In the context of a contingent contract, of course, all contracts of a nature where they are dependent upon an uncertain future event would be contingent. If that event is impossible in terms of the fact that it cannot take place, then again the consequence of this would be the contract. The transition of, in a way, of the more
Rohan sir, I'm sorry to interrupt, sir. So your audio is not connecting properly now. Rohan sir? Rohan sir? वो नहीं बोलने वाला. Ravi sir, are you able to hear me, sir?
I'm able to hear you.
So, but I think we have lost Rohan sir. Can you hear me, sir? So I think we've lost him, sir. I think it got disconnected for
Sir,
him.
we seem to have lost your audio.
No, he's not even there in this. Rohan sir is just coming back again online. I just require 2 minutes from all the participants. Yeah. Yeah. Yes. Yes, sir. And your audio is also quite clear, sir, now.
Yeah, yeah. So the host, I think, muted me by mistake. So anyway, can we get back to the slides and we can move forward?
Yes, sir. Yes, sir. So the slides are on, sir.
Okay, sorry, just give me a second.
Yes.
Okay, sorry, I can't still see the slides. Uh,
We are on the second slide, the legal provisions relating to force majeure.
yeah. Okay, so as I was saying before I was cut off, we don't have force majeure as a specific concept under the Contract Act, but under Section 56, of course, we have the doctrine of frustration, which focuses on the aspect A of impossibility of performance or two, illegality of performance. And then under Section 32, we have contingent contracts where if the future event on which the contract is contingent becomes impossible, then again, it will lead to a situation where a contract can be voided. Now, both 56 and 32 has also faced force majeure, of course, aspects of the doctrine of frustration and in relation to discharge of contracts. One of the things, of course, that we need to keep in mind is that under 56 and under 32, the consequence of your case being covered under either of these sections really would result in a voiding of the contract. And therefore, those situations, where you have a contractual provision of force majeure, the key aspect is going to be what is the scope of your language of force majeure, and under the force majeure, you may either contemplate a situation where the contract will then stand voided because it can't be taken further, or in certain situations, what will be provided is that if the impossibility is a temporary impossibility, that means it is a long tenure contract, but only for a period of time do you have a situation where parties cannot perform, then that really casts a shadow on the performance of the contract. But that shadow will, of course, lift in time. And at that stage, parties are restored back to their relative positions in terms of each of their rights and obligations. So either we will have a situation of avoiding, or we will have a situation where a temporary shadow is cast on the performance of the contract, but it could revive over a period of time. Now, if we go to the next slide and really see the foundational principles from which we draw the provisions of the Contract Act, then most of us who've sort of studied contract remember the Taylor versus Caldwell situation. And the issue again that is emphasized there is that the event must be unforeseen, it must be uncontrollable, and it must impact the contract to make it the performance of the contract impossible. The broader principle, of course, is almost a principle in equity, in terms of saying that if all of this occurs, then it would just be unfair or unjust to insist upon a party that they should perform under a particular contract. So in a manner, there is a complete synergy in the concepts across the English law, across the Indian law. And as we see judgments from other jurisdictions, we will see that this aspect of impossibility or illegality is something which is a recurrent theme in the jurisprudence all over the world. Now, if we were to see, how our Supreme Court has sort of effectively seen these, so we go to the next slide, and you've had different situations in which our Supreme Court has looked at it. In Satyabrata Ghosh, for the first time, as opposed to the pure doctrine of either impossibility or the doctrine of illegality, Supreme Court talked also with the aspect of impracticality. To say that if it becomes impractical to perform, then that is also a factor which is effectively required to be considered. That over a period of time has again got equated only to impossibility. So for a period of time, there was a thought to say that if it is not practically possible, and then some argued that if it is not practically feasible, that you could effectively plead frustration, which over time, as we see in Dhanrajmal, Govindram, etc., it has come down to the factor of re-emphasizing the factor to say two things. One, there was impossibility, and whatever happened was beyond the redemption or corrective capability of the contractual parties. So if there is an act whereby parties could have taken steps in mitigation and therefore avoided the impossibility, then that of course becomes a relevant factor, because if parties could mitigate it, then it doesn't fall in the framework of uncontrollable or beyond the control of parties. So the law has then sort of also evolved. If we see the next slide in Narmada Bachao, the issue which came up over there is that the law in relation to the activity of acquisition and certain governmental actions prescribed certain jurisdictional preconditions which had to be performed. Now, in that particular situation, those jurisdictional preconditions could not be performed. The question which came up before the court was twofold. One, whether the provision itself is ultra vires, and the second situation was whether in the particular aspect of that action or acquisition of land, was that legal or was that illegal? The court took it up to say that relevant to the particular contract, since the essential preconditions which had to be performed were now impossible of performance, that the contract would be voided and the contract will fall away. Relevant to the challenge on vires, the court said that, look, the framework, which is the statutory framework, that will continue to remain. And just because the jurisdictional preconditions are not capable of being performed at this point in time, it would not mean that the provision itself is rendered ultra vires. Now, if we go to the next slide, probably the one judgment which encapsulates the entirety of the law the best is the Supreme Court judgment in the case of the energy watchdog. And in this particular case, the situation is that the Supreme Court laid down 6 very clear principles in case we had to either plead force majeure or we had to plead frustration. So the first principle is that if your contract has a specific force majeure clause, then it is that clause which will be determinative of the issue. And if there is a force majeure clause, then there is no requirement to effectively look at the provisions of the Contract Act. Because if parties, through mutual agreement, have decided to write up their force majeure clause to have a certain amount of width and certain language and certain intensity, then that is what will become the definitive factor to recognize whether there is in fact a force majeure event or not and what should be the consequence of it. The second principle that it took is that the doctrine of frustration must tread very lightly in the context of contracts. And therefore, it said very clearly that the doctrine of frustration must be given as restricted a sense or as narrow an ambit as you can, because it is not for the law to step in to undo the agreement of parties. And therefore, the scope of the application of the doctrine of frustration, Supreme Court in this case, and again, from time to time, has reiterated that the scope is narrow and court should lean towards preserving the sanctity of contracts rather than holding that they have been frustrated and therefore should be voided. The third issue is that the aspect which must afflict a contract is actually a factor of impossibility, a factor of saying that it is more difficult to perform the contract, either because it is costlier to perform or it is more onerous to perform. Those are not factors which can lead to a frustration of a contract. So either it is an impossibility, but other than an impossibility, nothing should render the contract void. Now, the fourth principle was that if the substrate of the contract remains, if what the parties contracted for, if that substrate remains whole, then just because certain other elements have either become impossible or illegal, it is not that you will discard the entirety of the contract. And therefore, it is only when the substrate of a contract in its entirety disappears that we come to the doctrine of frustration. The fifth concept they took up is that you will plead force majeure only if there are no alternate modes of performance which are available. Now, the situation here very clearly is, and this goes back to some of the litigation which took place during the World Wars. Now, during the World Wars, the situation was that certain important shipping passages were closed. So, for example, the Suez Canal was closed. The Straits of Hormuz were not capable of being accessed by ships. Now, effectively took a view that if you had a contract of carriage as a shipping company, rule to the extent that those were not available, it did not become a basis for you to avoid performance of the contract. That even in such a situation, once you had an alternate mode, namely that you could find an alternate route, even if that alternate route added on many more shipping days and much more cost. But if you had an alternate mode of performance, then you had to pursue that and you could not claim frustration. So what the Supreme Court in our case has done, and repeatedly senior courts have done in other jurisdictions, is that a greater onus of performance is not a basis for a party to claim frustration. Now, given this as the clear principles which visit this situation, the question we must ask is the position altered in any manner because we face a widespread calamity or we face a universal challenge? And if we look at the next slide, our courts have dealt with, as have other courts, dealt with the situation of what happens when you have a event of a global repercussion. So in Satyabrata Ghosh itself, the factual scenario was that during the course of World War II, there was an agreement, which agreement was for the sale of a plot, but post certain work which was done on that particular plot. During the war, the plot was acquired by the military, and the issue went up to say that it is now impossible to perform the contract. The court, on looking at the circumstances of the contract, said, no, this is not a situation of a frustration, because what has happened here is, A, it is a long tenure contract. It does not have a specified time limit which falls within the period in which the war effectively occurred. The contract was for work to be done, post which you would have sold the particular plot. The work could not be done because of the war, but nothing prevents the work from being done once the war has actually come to an end, and therefore rightly the work should have been performed thereafter, and the plot with the anticipated structure should actually have been sold. So in this particular situation, the court actually said the doctrine of frustration doesn't apply. In the Sushila Devi case, what occurred is, there was again a contract for the sale of a plot. In the course of the partition, that particular plot happened to go within the sovereign geographical limits of Pakistan. And when the issue of performance of contract came up, the court effectively said that since this now is part of Pakistan, and it is no longer possible for the seller to put the buyer in possession, or for any Indian court to record a transaction in terms of land records or registry. Therefore, from that perspective, performance of contract is impossible, and this contract need not effectively be performed. If we look at the next slide, the next slide comes to a slightly different aspect, which is what happens when you introduce a new legislation. And why is that of some relevance? The new legislation, of course, was in the realm of law. We in the recent past have had notifications from the 24th of March, which notifications in a manner prohibit any citizen from going outside of their home to undertake any task. So we certainly do have now law, which law prohibits individuals from being able to go out and either perform a contract of personal service, or if a corporation was dependent on its workers to undertake performance of a certain contract and they could not be at the relevant site, then these are the issues which typically arise. And later we will discuss a judgment, a very recent judgment yesterday, in fact, of the Delhi High Court on this sort of an issue. So in this particular case of Rosen Millen, the situation was again sale of a plot of land. By statute and notification under statute, the plot of land got acquired, vested in the state. And the issue then came up in terms of the performance of the contract. And the view was that by the factor of the impact of the new legislation, since the plot of land now vested in the state, it was no longer in the ownership of the original intending seller, such that he could ensure a transference of property. And to that extent, therefore, again, it was recognized that what we have is an aspect of frustration. Now, if we take a slightly more global view of this and go to the next slide and look at some of the foreign judgments on the issue, then, if we see the US perspective, I think the US perspective on this is well exemplified by what happened after the 9/11 attacks. Now, there was a situation where post the 9/11 attacks, there was a large event in the nature of a concert to be held in New York. This was to be held in the February of the succeeding year. The organizers effectively cancelled the contract on the basis that 9/11 made it impossible for the concert to be held, for the reason that there was a fear psychosis in terms of any large grouping of people, and therefore, because it was unadvisable on account of the fear factor, they cancelled. A series of parties sued on the basis that this was not a justifiable and valid reason to cancel. The US District Court, which would be the equivalent of our high courts, effectively took a view to say that while the 9/11 occurrence was a material unanticipated event, the impact of that material unanticipated event was quite short-lived. That thereafter, USA moved very quickly to bring back normalcy, and therefore in the February of the succeeding year, there was no aspect of impossibility. And the claim of a fear and the fear of participation making it inadvisable was in fact a wrongful termination of the contract. And the court effectively said that performance either had to occur or there had to be an equivalent payment in damages. If we go to the next slide, this is a similar sort of epidemic, the SARS epidemic. And in the SARS, this issue was, several tenancy agreements and lease agreements came into question in terms of whether there had been impossibility. And the lead case actually was a situation of an individual who had a 2-year tenancy, but effectively was diagnosed with the SARS and therefore went into a quarantine for 10 days. And he pleaded that, for the 10 days, there was the impossibility of occupation. But also pleaded that, as a result, there was frustration and the contract should have been terminated or voided. Again, the court stepped in to say that it was a tenure of 2 years. The disability or impossibility was for a period of 10 days. And that period of 10 days of impossibility could not impair the entire contract or its performance to a level that frustration would be claimed and a contract could effectively be voided. And I'm sure several of you are recurrently getting queries from clients in terms of, what is going to happen to rental contracts. And, we'll spend a little time on that as a specific topic. But this was the approach of the Hong Kong courts. What also happened at that stage is, as you know, SARS was very centric to China. And the Chinese Supreme the Chinese Supreme Court has a special power. And that power is to issue opinions. And once they issue an opinion, it actually has the status of law in China. What the Chinese Supreme Court did very cleverly is that they declared an opinion to say that in their view, SARS was a force majeure event. And therefore, a series of Chinese companies who would have faced all sorts of contractual retribution in terms of the SARS, the court preempted the situation by saying SARS is force majeure. So the issue was not whether it's force majeure. The issue now only would have been that Chinese parties had to give notice. And once notice was given, they could seek to avoid contractual obligation by claiming voiding of contract. Now, what happened is once Chinese Supreme Court took this view, other countries, of course, contested this view. And, we have some amount of cases under the WTO, where this issue came up, and it was contested to say this is a unilateral view of the Chinese government. Now, whether SARS was God-given, whether SARS was unavoidable, these are all issues of debate. And therefore, they should be debated before the relevant court, rather than the Chinese Supreme Court taking on an onus to decide this issue for the rest of the world. So in that particular case, while the Chinese Supreme Court opined it is force majeure, other nations and other courts said that they will independently look at the facts of the case. If we go to the next slide, in UK, issues came up at a very large level in terms of all sorts of financial instruments which were in a way afflicted by the financial crisis of 2008. And the court very clearly came to the view that the financial crisis was essentially a series of events of bad calls made by either senior people in the banking and financial system, but it wasn't something which could be said to be an unforeseen event which was not controllable. From that perspective, for anybody to seek to avoid their particular financial obligations on the basis that there is a financial crisis and it's a global crisis was not a sustainable basis to claim frustration. So as we would see, all of these judgments are fact specific, but if we sift through the facts to come through to the principles ultimately sort of come down to, and if we go to the next slides, the principles come down to the substrate of the contract must be lost. That means that which the parties intended to perform must be so lost that what they are now asked to perform is a completely different contract. And that all sorts of reasons, which may be reasons indicating greater cost, greater difficulty, more onerous discharge of contract, all of these are not factors which can come in the way. The key factor, of course, is how have you written your force majeure? Is your force majeure wide enough, for example, in the current situation, to cover a pandemic, to cover an epidemic? Or if it consciously does not cover that, then do we go to the law of contract? The third issue which comes up is that if your force majeure contract does not cover an epidemic or pandemic, did you consciously as parties choose not to make that a force majeure event? So, all of these are sort of issues which will emanate from the facts, but impossibility, illegality, as distinguished from inconvenience or higher cost, really becomes the central theme. Now, coming to the COVID, if we go to the next slide, is COVID force majeure? Is a question which could come up, and I think it's not a question which sort of should be debated anymore, because whether it's the World Health Organization or whether it's China, which again has issued some 5,000 certificates to its contracting parties to say that, there is already force majeure. Or if we look at, what has happened through notifications of our ministries, we have the central notification, for example, on 24th to say the lockdown was effective 25th. In certain states, Maharashtra, for example, it was 21st. The question comes up that if your contract was afflicted, can you only claim protection of impossibility post 25th? Or can you also claim it from the state law? And what happens in the period where the pandemic was in a way bubbling over, but you did not have the notifications? Now, from the date of the notification, you can say that it was unlawful to go out and perform. But pre that, what is the situation? Now, under Indian ports, of course, the relevant authority has issued a notification to say if there was non-compliance by port authorities, it's attributable to force majeure. So we are already beginning to see, the start of that avalanche of litigation, which, we can expect will sort of come in. Now, if we go to the next slide, and look at it from the perspective of your corporate clients or your individual clients, the nature of the issue is likely to manifest itself into A, what will happen to operational contracts, B, what will happen to employment contracts, third, what will happen to different service contracts, and the fourth, what will happen to financial contracts. Now, in the context of operational contracts, let me just share, some aspects which are coming through, which are really signaling a very deep distress in the economic system. And of course, all of us are being continually fed by the media and economic experts on, the rather dark prophecy of what is going to happen to the economy. But let me just share one or two pieces of information. One, the World Trade Organization, which looks at the global trade both in merchandise and services. The World Trade Organization estimation is that merchandise trade globally will fall between 13 to 32%. Now, if their worst prophecy comes true, then 1/3 of all merchandise trade in the world will actually be wiped away for a period of between 12 to 24 months. Now, if we are to just look at this in the context of how commerce is done today, the huge push towards globalization from 1994 really created a system of very large global dependencies. So nations only manufactured what they were efficient at, or only provided service they were efficient at, and the rest of it they were dependent on other trading partners. And as a result, this very, very high dependence on China or partly on India, Thailand, Bangladesh, etc. Now, in this dependence, we all move to these dependencies secure in the knowledge that globalization is the indefeasible mantra, and free trade of goods is the lifeblood of commerce all over the world. Cut to the factor of the Trumpian era, where from globalization we moved very firmly to localization, not only in the US and the resultant trade wars between US and China, but you are seeing that as a trend even in the UK and elsewhere. So all the former champions of globalization, in a way equally vociferously, are going back to localization. What does it effectively mean? If you have a client who is either import dependent on raw materials or components, or you have a client who is export dependent for turnover and profit, in both these situations, you must expect that there will be a very deep, deep dislocation of the supply chain. Raw materials will not be available, or will be available in far lesser quantities and in far longer time periods than is originally committed. In export contracts, you will find cancellations, you will find price renegotiations, you will find every attempt to avoid honoring the export contract. And therefore, in these situations, how will the doctrine of force majeure come into play? So, of the points that I put down, let's take a situation where you are an Indian exporter, but the government of India has now imposed a restriction banning your ability to send out certain pharmaceutical products or API products. Now, clearly, you are afflicted by what is a government notification which makes your export illegal, and therefore you're afflicted by an illegality. And the illegality will be your basis to claim frustration of the particular contract, right? Now, if in this sort of a situation, you, however, had a variation that you have an export commitment, however, because your workers cannot be brought to the factory, because your raw materials are not available, it is now in a manner almost practically impossible for you to make what you should be manufacturing for export. But this is not something which falls within the classical legal doctrine of frustration or of force majeure, because you now have productive assets which you have not been able to find either in the abundance or at the cost or at the time that you should have found them. And therefore, factors of uh, unavailability of labor, unavailability of raw materials will not immediately lead to your being able to claim frustration. Those are situations which will open up the door for renegotiation, but certainly not for frustration. Likewise, you will see shipping companies all over the world. Ships are manned by crews which are typically drawn from different nations. All crews need permits. The first basic requirement is visas, and to the extent that India, for example, will not accept ships from certain countries if they are manned by crew from certain countries. The situation is that your deliveries, even post export, really cannot be made. And in those situations, issues have arisen. Shipping companies have themselves had issues of default. Exporters have issues for default because importers are saying my goods have not reached port on time. Now, again, each of these will be factors which you will look at from the aspect of whether this is an impossibility, whether in a time-bound contract, it's certainly somebody may say impossibility. Why? Not because of the unavailability of crew, but if there were port notifications in India, whereby it was illegal to accept a ship from certain countries or accept crew of a certain ship, and the ship had already sailed or the crew was already on board, and therefore it's now illegal to handle the cargo, then again you can plead illegality. So you will see several of these issues play out factually. Recently, we are seeing the situation of insurance contracts. Two of the IPL teams did manage to get an insurance contract, which also covered pandemic. And from that perspective, these two teams, were feeling quite secure that, they had got the pandemic cover. But lo and behold, both the teams on the 25th received a communication from a national level PSU insurer saying, I hereby return your premium, I hereby return your GST, kindly treat the contract as cancelled. Now, obviously, this brings up issues because it is a PSU and therefore state, whether they've acted in the manner which is arbitrary, whether they've acted malafide. But what is now going to happen is different shades of commercial contracts will effectively come up in streams of litigation. And therefore, as a lawyer, as you look at these issues, what would be the list that you go through? So if you go through the next slide, which says operational contracts, your future course of action, obviously the first question you would ask is there a force majeure clause? And if there is a force majeure clause, you need to see the language used, the width of the clause, and the consequences which are mandated by contract. The second situation you would have to see is whether the COVID renders the contract impossible, or does it only cast a shadow on performance for a time period which will then ultimately lift. You then also need to understand that given the consequences of the force majeure, one, is the event of the pandemic covered by the force majeure? If not, will you now have to go to section 56 of the Contract Act? It will be important for you in case of each individual contract to identify and establish the factor that, of course, this is an extraordinary event. It was beyond the control of your client. And you will examine three critical issues post seeing the force majeure. And given the true nature and essence of the contract, the first issue would be, is the entire substrate of the contract destroyed? If it is destroyed, then of course one can plead frustration. If not, then one has to evolve new equities through negotiation. Now, if the substrate is in fact destroyed, is that destruction directly linked to the, or is it linked, for example, in a, let's say a contract of personal service, assuming your personal service had to be performed on 27th March when the whole country was in a lockdown, then is the factor of the substrate of the contract becoming impossible linked to some sort of government legislation? If your answer is yes to the first question and either of the next two questions, then of course there is a case for frustration and therefore voiding of contract. If not, parties must proceed further. Now, typically in a court, you must also show, did you take steps in mitigation? If so, what were those steps in mitigation? Did you take reasonably diligent steps will be the test. There is a notice requirement. Either it's a contractual notice requirement, or even if not, you're well advised to sort of issue notice, bringing the facts and the impossibility to the notice of the counterparty and stating very clearly what it is that you desire, either a renegotiation or a rescinding or voiding. So, each one of us, in a way, will almost have to use these sort of pointers as a primer in terms of every one of these issues which sort of comes to us. Now, if we go to the next slide, the one issue which is coming up, and not only is it an important legal issue, but it's also a heart-wrenching emotional issue, because many companies are already in the phase of uh, affecting their labor contracts in one of three ways. The most severe is that they are laying off staff. The second situation is they are retaining staff at same salary, but entirely forsaking bonuses and other incentives. And the third is that they are wanting to retain staff, but at a significantly lesser salary. Now, depending upon the nature of the employee, of course, the most vulnerable are the contractual employees, especially if there is ability for the employer to terminate contract only upon notice. And, in many situations, there is a contract with one party who sort of supplies all the labor. So today in all the food delivery services, or in, the delivery networks of the e-commerce sites, you have a certain contractor who then provides you on the day, 700, 500, 3,000 people who will sort of make the delivery. Now, these have been the easiest to cut back on, because, you've only terminated with the contractor, or your intimation of what you need, you have reduced by 70, 80, 90%. Where you have permanent employees, even if they go through for a salary cut, you have certain statutory contributions to be made. And those statutory contributions were required to be made on negotiated salaries. You have in the past made those sort of contributions. The question comes up, do I need to continue to make my statutory contributions even though, the salary has effectively been cut? The more conservative view is that the statutory obligation has not been relaxed. That being statutory, you have a ongoing onus of compliance. However, you can renegotiate the contract with your employee, and if it is by mutual consent, then of course you have a new contract at new terms. Many companies in these very difficult times are, making a plea to government to say that there must be a commensurate adjustment even in those obligations where they have to make contributions which are statutory contributions. Now, from these, of course, the most difficult realm of contracts, if we go to the next one, next slide, is the financial contracts. And the reason they are difficult is that, one, financial contracts actually have no force majeure clause at all. They are typically one species of contract where force majeure is not a prescription. And the right of financial institutions typically is upon identified triggers, and is to that extent what one might say is almost untrammeled. Now, within this, and if we go to the next slide, one of the issues which has kept coming up, and I'll take you through a few case laws in the next few slides, but the two most recurrent issues which have come up is that you do have a rollover or a moratorium, in certain days, certain cases 90 days, in certain cases cumulative 180 days. And those are the ones which say that you needn't pay interest, but you can roll it over and you can accumulate it. There are guidelines on recognition of NPAs, and in this period we will not recognize NPAs. There have been allied issues in terms of those promoters who have pledged shares, and because of the steep fall in the stock exchange prices, the financial institutions have wanted to sell those shares. And in certain instances, we have got injunctions from Bombay High Court, etc. on those. There are other situations on letters of credit, because letters of credit, are required to be answered. They are contracts exclusive of the core commercial contract. So each of these issues has, come up. And if we go, to the next slide, which is recent High Court judgments, and let me just, discuss each of these in some detail. So the situation in rural fair price was that the promoters had pledged shares as a security towards the loan. The value of the shares pledged was, let us say, at 100 rupees. In the fall of the stock market, let us say the value of the pledged shares went down 50%. So the banks immediately asked for 50% more shares to be provided as a pledge. Promoters, of course, did not have these. And therefore, the action which was proposed is to sell the pledged shares, which again would have been a recipe for disaster, because when that quantum of shares comes into the market, then the downward spiral of pricing will exaggerate. And, the bank will have to sell more and more at lower and lower prices, which means there is complete value destruction for all other shareholders also. So in this situation, the Bombay High Court saw this as a circumstance where the irretrievable harm which would be caused to the promoter was seen as being greater than the need for the security and encashment by the particular bank. Therefore, temporarily there was a stay. The IDBI trusteeship carried the matter to the Supreme Court. Supreme Court, of course, said, look, the matter is coming up very shortly in Bombay High Court, so, take it up again over there. But quite clearly, in a normal circumstance, it would have been impossible to stop a financial institution from selling pledged shares. But because of the impact of the COVID, the court stepped in to protect. Now, the other situation, again, where this issue came up, and actually this particular judgment of the Delhi High Court in Anantaraj considers all the RBI circulars on the issue. And, the situation was a bank loan had been taken. There had been consistent payments, at every due date and milestone. However, on the date which fell within the COVID period, they were not able to effectively make payment. In fact, all cash flows had effectively stopped. And the issue which sort of came up is, how will they now be recognized? What is to be done? And the number one issue was, should they be classified as an NPA? The court effectively again stepped in. It's a very good judgment of Justice Sanjeev Sachdev. He stepped in to say, look, this is a completely unusual and unprecedented circumstance. There has been clear conduct of the party to show diligence in repayment. The particular repayment which fell due in the COVID period, there was clearly impossibility. And it would be too harsh a consequence for them to now face the consequence of being characterized as an NPA. And again, there was a stay which effectively came about. If we go to the next slide, this is Bombay High Court, but in a slightly different circumstance. Here, now the situation was that a letter of credit was issued by an Indian buyer to a Korean supplier. The Korean supplier put the goods in the course of delivery. He shipped them. The ship couldn't effectively berth at a port in India because there were notifications. Situation was that the buyer went to court saying, protect me, the letters of credit should not be encashed. The court approached it on facts and again also on legal principle. On facts, it said that, customized goods which were ordered had been shipped. Intimation of shipping was given. The goods, in fact, were placed on board ship with appropriate insurance. And there was a problem which the buyer claimed in terms of goods not being able to land at port. But there is, in fact, a notification where delivery of steel is seen as delivery of an essential. So actually, the port was obliged to accept these goods. And irrespective of all these facts, the underlying contract for supply and the LC are two completely different contracts. And to that extent, therefore, whether or not the core commercial contract stood frustrated or not, the LC was not something which could be injuncted. And whatever were the obligations on the LC effectively needed to be discharged. Slightly different from this as an approach, if we go to the next slide, and as I said, this was the judgment which came yesterday, Delhi High Court, Justice Hari Shankar. Now, the situation here was that Halliburton, who is a contractor, was undertaking certain work for Vedanta in terms of certain oil wells. There had been proper discharge of contractual performance. There had been some delay, however. There were 8 bank guarantees given by Halliburton to Vedanta. And if the delay went beyond the point, Vedanta could effectively encash those bank guarantees. Halliburton moved the court to say encashment shouldn't happen because there was a special circumstance. Dr. Singhvi argued for Vedanta to say that it is only in a situation of egregious fraud that anybody can interdict a bank guarantee. And therefore, the law is that absent egregious fraud, there is no circumstance in which you can interdict a bank guarantee. Justice Hari Shankar, having looked at the facts, namely of performance, even though with delay, and having recognized that 95% of the work by acknowledgement of both parties had already been done, the situation then was that only 5% remained and workers couldn't be brought to the site, and therefore that 5% remained. Justice Hari Shankar sort of looked at Himadri, looked at the Standard Chartered, and he said that it is wrong to say that it is only fraud or egregious fraud which is the only circumstance. There are 2 other circumstances. One is irretrievable harm or injustice. But while irretrievable or harm or injustice has always been a doctrine, in his view, Supreme Court went a little further in Standard Chartered by introducing a third aspect, which is special equities. And he said that while earlier the view is that special equities are in a way embedded in irretrievable harm, in Standard Chartered, Supreme Court uses them in the alternative as irretrievable harm or special equities. And therefore, he said this case falls squarely within the special equities label. And in this case, he said, although they are bank guarantees, as an interim measure, he granted stay and injuncted the encashment of the bank guarantees. Of course, there were other issues in terms of, parties moving forward, having to provide evidence, affidavits, etc. But the entirety of the basis, as you can see, is that courts are more and more leaning towards recognizing that this is a unprecedented event in the history of mankind, and therefore certain protections, effectively must be offered to keep the wheels of commerce turning. So I'm sure many of you will have occasion to test these out before courts. But, even as many of these have to be tested out in courts, obviously the predominant focus really needs to be either on some legislation which will obviate litigation, or a certain amount of commercial sensibility where people will renegotiate. And if we go to the next slide, this is the COVID legislation that Singapore has come up with. And it's a extremely wise piece of legislation. First of all limitations for all issues, whether it is for filing, whether it is for enforcement, whether it is for dates of performance, all performance dates have been extended by 6 months. Therefore, for 6 months, there can be no breach of performance. For 6 months, there can be no enforcement of guarantees. For 6 months, there can be no enforcement by coercive steps of recovery. Limitation periods are extended by 6 months. And in a way, they have created almost a legislative safe harbor for 6 months to say that within this period, nobody should be in an active litigation on a contract with a Singapore party, especially to interstate Singapore parties. And that courts will play a role to find a commercial solution, but in a way obviate any manner of litigation. Now, in our context, depending on the statistics you believe, there are probably somewhere close to 6 lakh pure commercial cases, pending within the principal high courts, and another 3 lakh odd in the Supreme Court. The estimate is that lesser than 1% of contracts are litigated, and therefore go into either the court system or the arbitration system. Now, the global expectation is that almost 5% of all contracts will now enter some field of contractual litigation. Now, if that happens, and our quantum of contractual litigation goes up 5 times or 7 times, depending upon the threshold, you can well imagine what burden it is going to place on the court system. Of course, it will create opportunities for lawyers. But, as a system, what it will mean is further delay, and further delay on contractual issues means that money is actually then not running through the economic system. That money is then stuck with one party or the other. And, the normal wheels of commerce that a court talks about are just not turning. So I think, we are all coming into a challenging period, even in terms of our own practices as we go back to working full time. And many of these issues will come to you. And, we will all, in a way, be tested, both in terms of the learning and in terms of undoubtedly the innovation that we will see in the context of, I don't think either the doctrine of frustration or force majeure will remain static. I think for new commercial problems, new legal solutions will be found. And, hopefully we'll all be part of that growth and that innovation. So thank you very much for this opportunity to speak to you. And, I'm happy to take any questions that you all might have.
So thank you very much, sir, for your wonderful presentation on this topic. May I call upon our participants to ask some questions? If there are any questions, you can raise your hand. I can unmute you, and then we can raise the question. Raise the hands in the app. There is an option of raise hands. Yes, sir. I think that we have 2 questions in line. 1 minute. Mr. Sivakumar, you can ask a question, sir.
Sir, good evening, sir.
Yes.
Good evening, sir. Advocate Chennai from Chennai.
Yes, sir.
Yes, sir. I want to one doubt, sir.
Yes.
If the employer of some resort, now the lockdown period, now what is she must to pay for his workers, employers? Whether statutory obligation. You said in your lecture only the statutory payment has to be paid. That what is the statutory payments?
No, so I think the correct position in terms of what I said is twofold. One, you will of course have to see your employment contract with your employees
Okay, sir.
as to whether you need to pay them irrespective, because they have made their services exclusively available to you even in the lockdown period. It is that you have not been able to utilize them. So, qua your employee, obviously the situation is you have to see the contract. Qua the statutory obligations, whether it is ESIS or whether it is PF contribution, etc., or under the Indian Industrial Disputes Act. Now, under all of these acts, there is a onus of contribution, which onus of contribution is implicit. And the acts today do not contemplate any special circumstance in which this onus is alleviated, or you are exempted from the onus. So today the view is that yes, you will have to make those statutory payments. As I said, there is a move already afoot, both with state governments and central government, to say please grant an exemption, because in this period for us to make statutory contributions when we are not earning anything is impossible, and it is placing an unfair burden. So for statutory obligations, there is as yet no exemption. There is a requirement to pay, but industry is pleading with the government to issue some sort of relaxation or some sort of exemption.
Yes, sir. Thank you. Thank you, sir.
Thank you, sir. Mr. Gururaj,
Yeah,
you're online.
I'm Gurraj from Bangalore. I have a question. In the context of non-residential rental or leasing agreement, for the period when this disaster management notification is in force, can a party claim excuse from paying the rent, or maybe renegotiation only for the limited period? What is your view on that?
Again, while we would have to see the contract, let me tell you some of the issues which are coming to me from clients, right? So there are very large companies who have taken, let's say 100,000, 200,000 square feet for their BPOs and whatever. Now they have written to the landlord to say that, we took these to house our employees, but there was a restriction, nobody could come to work. So therefore, please forego the rent for 3-4 months. Now the landlords have come back saying that, look, I have made my premises available to you. I have not defaulted. I am continuing to store your servers, your furniture, your computers. I am keeping my own security to keep them safe. So I have made my premises available, and you are in a manner still using them, even though your employees do not come. Now, these issues are going back and forth. And I think the practical solution which is emerging is that, at least I'm now talking Bombay, Pune, even Delhi, that landlords are foregoing the entire rental for April and may also do so for May. And in some cases, they are charging for 3 weeks of March. But, they are willing to forego. Some of them have, of course, said that I have discounted your rentals with a bank, and, I have already taken money, so I have some interest to pay to the bank. So, maybe we are agreeing to pay interest to the bank. So I don't think one definite position has emerged, but even the largest landlords are willing to give some sort of cushion in relation to relaxing either 1 month or 2 months of rent.
Thank you very much.
Thank you, sir. Mr. Gokarnation sir has a question, sir. I'll just put him on. Gokarnation sir, you're online. You can ask your question, sir.
I think he's still muted.
No, I have one minute, sir. Check on.
Okay, sir. Okay, sir.
Gokarnation sir, we can hear you now.
Good evening, sir. Good evening, sir. Thank you very much for the presentation, sir. I have only two queries. One query is regarding that I am a manufacturer entered when you get damage due to flood or natural calamities, all these things. Now, due to Corona, the machines are idle for more than 50, 60 days and got damaged. So, can I claim insurance from the company based on that policy? Then what would be the stand of the insurance company? Will it be considered as a natural calamity? Number one. Number two, I am having a commercial rental business to other customers. I waive the rent because of this Corona, all this lockdown, all these things. I decided to waive the rent for my tenants. But the GST department, normally, there's no consideration for these 2 months for me as a commercial rental value. But however, free service, it will be taken as a free service, and there is a government levy GST on that. That's the two questions I put forth. Thank you, sir.
Yeah. So in terms of the insurance company, of course, we'll have to see the insurance policy. But to the extent of whether this is a natural calamity, as I said, there's almost a universal recognition that this is force majeure. Whether it's WHO or whether it is, our government or whether it is many other governments like China. So that it is a natural calamity or it is a force majeure is accepted. Obviously, one needs to see the terms of that particular insurance policy. But if it covers natural calamity, you would have a good basis to say that this is a natural calamity. And, to that extent, see what, your claim can be. Is it to refurbish the machine so that they are workable? Or is it to, get from the insurance company the price of your machines? That you need to see. But is it a natural calamity? Yes, it is. And, you need to sort of fit it into that. Insurance companies, by and large, have a reputation of finding some way to avoid. So, that is the battle you will have in any case. As far as the GST is concerned, again, yes, to the extent that a service is chargeable, but you don't charge, then they will impute the past rental to these transactions. But I think very clearly you will have a clarification coming through very quickly to say that in these situations where rental is foregone on account of the pandemic, both parties will have to file a letter evidencing consent of waiver of rental, and based on that particular letter, there will be no further requirement for payment. This has not come as yet, but I expect it to come quite soon.
Thank you. Thank you very much, sir.
Thank you, sir. Sir, with your permission, sir, there are 2-3 more questions, sir.
Sorry, can we take the last one? I have another call at 6, but
Sure, sir.
The one question has come up whether this presentation can be shared. Of course, it can be shared. It is just
yes, sir. That I have already got the mail, sir. I will forward it to whoever has sent me the mail ID. I'll do that, sir. So, shall we take a one question, sir?
Yeah, you feel free to.
Yes, sir.
Yeah, sure.
Hema ma'am, you're on. Fine.
Sir, this is a continuation to that lease rental. So we all of us have been only talking about big lease lessons and lessees where there is a major clause present. But let's take as a case of a small person who does not have a force majeure clause in his agreement. Will the court still say that the lessee will be eligible to take up the force majeure clause and enforce it? Because when looking at it from the landlord's point of view, that is his only source of income.
No, madam, if you don't have a force majeure, then of course the option will be that you plead under section of the Contract Act, and you plead section 56 on frustration. Now, of course, it is not a frustration where you may claim a voiding, but it certainly is a frustration where there has been a temporary disruption or impossibility of performance. And on that basis, you can plead. And in this circumstance, as I said, courts are being sensitive. I have every reason to believe, even if you don't have a force majeure, your landlord will agree, but if he doesn't agree, a court will certainly sympathize and waive some of the rent, if not all the rent.
So that therefore that will end up only with most of a mutual understanding, because from the landlord's point of view, that is his only source of income.
Yeah, I mean, sorry, I couldn't hear everything you said, but my sense is that yes, either it's mutual negotiation, and hopefully it is that, because in a small matter, the cost of litigation may outrun the amount
Yes.
invested.
The cost of litigation is to be considered by both sides first.
Yeah.
Thank you, sir.
Right. Thank you all. Thank you very much, Ravi. Thank you for this opportunity, and thank you all for making the time. Please stay safe.
Can I come in now?
Yeah,
Yes, sir.
please. Sorry. Yeah.
Okay. Rohan bhai, there are a number of messages which say that, look, it was extremely good, very useful, with latest case, all kinds of adjectives are available. To sum it up, I would, and I'm sure many will agree, Rohan Shah, thy name is clarity. That's my final comment that I will make. But there was a demand from a few people in the morning that, look, he must talk on tax subject. So, that demand came from quite a few people, and one of the senior standing counsels, AP Srinivas, told me, you must make him talk on tax. So I will leave it to you whenever you can do it. But what I thought you will do is take 5 top tax matters pending in the Supreme Court, both on the direct and indirect taxes, and talk to us on the possible outcomes and explain how it will affect the tax planning, both basically Indian tax planning, as also look at inbound and outbound structures in those matters. With that, I thank you and hand it over to Mr. AP Srinivas to close the proceedings.
We are extremely privileged to say the vote of thanks, sir. We are really honored by your participation in our seminar. It was wonderful. You have covered both Indian and as well as foreign case laws. The case law watch case was considered as Indian jurisprudence, which is not even